to the Putting Your Business on the Map podcast. This is the podcast for land surveyors that own or want to own a small business. My name is Landon Blake. I am your podcast host. Let's dive right into today's episode. The title of this episode is Copyright, Licensing, and Liability for Digital Survey Deliverables. If that isn't a topic that will put you to sleep, I'm not sure what is. Bookmark this for when you're having trouble catching your Z's. You can listen to it and you'll probably go right to sleep. It is important. It's technical and complex, but it is important. This is a follow-up to the article I did on contract basics for land surveyors. Let me just tell you right at the top, I don't have all the answers here. There's things that I could do a better job of personally. And that we could do better on as a business. So I don't want to pretend like I have this all figured out because I don't. And then I also want to remind you that I'm working on my word whiskers. So is my favorite word in the entire universe. I'm working to eliminate those. If you see me hesitate a little bit or hear me hesitate, it's because I'm trying to speak without using a word whisker. I tend to plug those word whiskers in. See, there's an when I'm thinking about what I'm going to say next. So I'm trying to replace some of those pauses with silence. I will also try not to bang my stinking microphone or my desk. Okay, I just realized I want to turn off my phone too. I don't even know where my phone is. Oh, my phone's right here. Let's just make sure this is on silent. I need a little checklist. I'm a checklist Nazi, but I need a little checklist before I get ready to podcast. All right. Let's see here. Okay. What are we going to talk about today? For most of us, for most land surveyors today, our deliverables are digital, not physical. You know, in the old days, I don't know, 40 years ago, 30 years ago maybe, the deliverable was physical, not digital. Right? So it was a printed topographic survey on bond paper, or was a boundary survey on Mylar. There was some, physical document that was delivered. Maybe it was a typewritten technical report. But we rarely do that anymore. About the only time I have to actually print something on physical material is when I'm dealing with a government agency that's stuck in the 1970s. So my private sector clients just don't want paper. They want digital deliverables. It's usually a PDF, but depending on the project, it could be an actual drawing file or a set of GIS data files. So our deliverables now are digital. I use the word deliverable intentionally. I don't say work product. I don't. Sometimes you'll hear me slip work product. I don't like the term work product because surveyors are professional consultants. We have deliverables, contract deliverables, but we don't have work products like a contractor might. So I'm going to use that term. I'm going to try and use that term, survey deliverables, in this episode. Because we operate in a world where deliverables are typically digital, for most surveyors and for a lot of other professional consultants, we have to deal with the additional liability that comes with that. And there is additional liability. Why? Why is there additional liability? Because unlike physical maps, digital files are much more easily replicated or copied, and they're also much easier to modify. We'll talk a little bit later in the podcast about some things you can do to kind of digitally fingerprint your files. Your digital files, but they're, sometimes people say, oh, it's a PDF, it can't be manipulated. Yes, it can. You can absolutely manipulate PDFs. So we have to deal with that. It's much easier to copy our data and for that data to get into the hands of people that don't understand the limitations or the purpose of the deliverable. And it's much easier to modify the files. And this causes lawsuits. I've seen it happen in my own career. We had a big construction job we were working when I think I was just newly licensed, and I was working for a company on we had a big transportation project we were working on. And there was a difference between the CAD files and the PDF plans. And there was a big issue. It was a huge change order. It was in the order of tens of thousands or maybe even $100,000 or a couple $100,000 of rework, because we laid something out off the CAD file when the engineer told us to do that, and it didn't line up with the PDF. So this happens, right? These are issues. Having the authoritative version of the digital file and having that be technically correct and accurate is important. And when that doesn't happen, it costs money. So that's why we need to think about this. One of the things we're going to talk about today is a misconception that I think a lot of land surveyors and other professional consultants have. They have this misconception that copyright protects their contract deliverables. And there are ways to protect your contract deliverables. Copyright is almost never one of the ways to do that, the proper way. So that's a pretty fundamental misunderstanding. And there's a widespread misunderstanding about copyright in American society and what it protects and what it doesn't. And I see surveyors suffer from this cultural misunderstanding or blindness. So we're going to talk about that. So what we're going to do in the episode is we're going to go, what we're going to do in the episode is we're going to go over copyright basics. What can you and can't you protect with copyright under U.S. law? How does that apply to land surveying? We're going to talk about an interesting Supreme Court case from 1991, just a little bit. We're going to talk briefly about the difference between copyright and patent and what you can protect with patent. In part 2, we're going to talk about licensing. So licensing of your digital data. That's actually the most effective protection you can have. So it's much more effective than patent or copyright. Then we're going to talk about, in part 3, what are some practical things you can do from the file management side to try and protect yourself. And then finally, in part 5, we're going to talk about, what are some common pitfalls you got to watch out for with digital deliverables. I've got a couple examples that I'm going to use. And if we have time, at the very end, we'll talk a little bit about, things that are different when you work with government agencies. So generally, when you work with government agencies, you're going to be very limited in what you can do to protect yourself from liability that come from your digital files. So we want to talk about that. All right, so that's a lot to cover. Let's see how we do here. So we're going to start with part 1. What does copyright actually protect under U.S. law, and how does that apply to your surveying deliverables? The basic rule in the United States is that you can't copyright facts. Okay. The color of my pickup truck. My first name, middle name, and last name. My social security number. My birth date. My dog's name. The breed of my dog. The fact that I live in Stockton, California. The fact that the San Joaquin River terminates in the Sacramento-San Joaquin Delta. The latitude, longitude of my office building. That's all data. It's all facts. You can't protect any of that with U.S. copyright law. Now, before 1991 in the United States, there were some jurisdictions where you could protect an assemblage or a collection of facts under the sweat of the brow legal doctrine, which recognized that it takes money and time and money to assemble facts into like a database or a repository, and that effort deserves some protection. But in 1991, there was a Supreme Court case called Feist Publications versus Rural Telephone Service, which was about a telephone book that somebody copied. And the Supreme Court basically said, yeah, in the United States, you don't get to protect collections of facts. Now, it's a little more nuanced than that. If your collection of facts has some creativity in how it's organized or how it's presented, you may be able to copyright those creative elements. But you just can't copyright facts. You just can't. So as an example, if I put a survey grade coordinate on every section corner and quarter corner in San Joaquin County, that is super valuable data. I can't copyright that. I can't protect it with copyright. I have to protect that as a trade secret or license that data, but I can't sue somebody under copyright law. The latitude, longitude positions on those monuments are facts, and they're not copyrightable. What does that mean? What are the practical implications of that? The reality that we can't protect collections of facts with copyright under the United States, in United States law, as a general rule. That has pretty huge implications. Almost everything a surveyor prepares is a collection of facts as a contract deliverable. Now, sometimes we provide opinions. You might have a report with an expert opinion, but most of everything else you provide, other than your expert opinion, can be construed as facts under the law, and that means you can't copyright it with. You can't copyright it with. You can't protect it with copyright. So what type of things am I talking about? What type of survey deliverables can't be protected by copyright, more than likely? Topographic maps, boundary surveys, point clouds, orthophotos, the contents of your GIS database, coordinate data, elevation contours. It can be very difficult to protect any of that under copyright. So what can you protect with copyright? Your custom north arrow. A lot of surveyors have a custom north arrow. There's probably some creative expression there. If it's unique enough, you could protect that with the copyright. Your company logo, if it's unique enough, your custom scale bar. Your marketing material, if it involves enough creative expression, have a unique map design that involves some creativity, you could potentially copyright that. But 98% of what you produce as a survey deliverable isn't going to be protected by copyright under U.S. law. And I don't think a lot of surveyors or professional consultants understand that. And you can get a different kind of protection with patents. So patents under U.S. law protect inventions, processes, or designs. So you could potentially process, patent a process you have. Maybe you have a CAD, a process for your CAD system. You could potentially patent some of your CAD standards if they were unique enough. You could patent an algorithm you developed to process LiDAR data, potentially. So that's intellectual property, but it's not your deliverables though. It's your processes. That is more related to process than it is to deliverable. So patents can protect certain intellectual property in your business. We need to do a whole episode about intellectual property, but they're not going to you're not going to be able to use them typically to protect your survey deliverables. So what's the takeaway from what is the takeaway from part one? You can't use copyright to protect most of your survey data. What's the effective alternative? And patents aren't applicable either. So what is the alternative? Is there an effective alternative? The answer is yes, there is an effective alternative. It's licensing. So that's part two. Licensing is the actual mechanism you use to protect your data. Since you can't protect your survey data with copyright, what you use is a license. Okay, a license is a type of contract, and we usually include the data licensing language in our contracts as surveyors, our project contracts. A license gives permission for someone to use the data you produce as a surveyor under specific conditions. And that is the effective legal mechanism in the United States to control what happens with your data and limit your liability. You see this all the time when you download software. When you pay for software, you're not buying software. You don't buy your CAD software from Autodesk. You think you do, but you don't. What you pay for is a license. It's a right to use the software subject to certain terms and conditions. It's a contract. They are licensing the use of their software to you. So you don't own it. So you use licenses all the time, whether you realize it or not. So what you want to do in your standard contracts is you want to address the licensing of your data. So here's the key this is for private contracts. Here's the key element. You have two options. In the first option, option one, you retain ownership of the data. That's what you want to get if you can. And then you grant your client a non-exclusive license to use that data for a particular purpose. So you keep the right to use it for other projects, to use it for other clients, to use it for marketing purposes. The client can use it, but that use isn't exclusive to them. You reserve the right to use it for other purposes. And their use of your data is subject to some reasonable limits. That's the best thing you can do. That's what protects your interest, provides the highest protection for you as a survey consultant. And that's what's in our standard contracts. And you can't always get that. Sometimes the client says, nah, we want to own the data. And I understand that. If you're working for homeowners, they're not going to care. If you're working for a big civil engineering company, they might care. Or a local city or county, they might want to own the data. That's understandable. And so we try to be flexible. Option two, if you can't retain ownership, if your client doesn't want that, if they want to retain ownership, you transfer ownership to the client. So they own the data outright, but then you want to reserve some rights and limit your liability if you can. So you want to try and get your client to give you a release of liability if they distribute your data to third parties without your knowledge. You want them to have a duty to defend you if a third party they distribute your data to sues you. If they're going to own the data and have the ability to redistribute it, you need some protection if they decide to give that data to a third party who then misuses the data and sues you, right? So there's a duty to defend there. And you want, hopefully to get some release from liability if they use the survey data for purposes beyond what you agreed to in your scope. That's why it's really important to get a project understanding in your scope of services. And then you want to know, can you reuse that data for a different client? Can you use it for marketing purposes? You should make that clear in your contract. That's basically the two options you have with private clients. You want to try and go with option one. If you have a client that insists on owning the data, you can accommodate that as a land surveyor, I think. But as a business owner, you want to talk about some reasonable protections and limitations in that situation. Okay, this is critical now. This is really key, and I'm going to give you an example. In either scenario, option one or option two, you need to make it very clear in your scope of services and your contract documents what the data can be used for. In other words, what the purpose is. Because if the client or a third party uses the data for something beyond its intended purpose, a lot of problems can come up, and then you can get sued. That exposes you to liability. So I'm going to give you an example of how this happens. You get hired to do a UAV aerial survey for, let's say, a commercial development. And the land developer, the client, is just trying to get through the planning process. So they're just trying to get entitled. So all they need is an orthophoto and some contours, so their architect can prepare a rough site plan to get through, start the entitlement process. So you do that. You tell the client, you say, hey, if you want to use this for design, we need to set good control, do some ground infill surveys where we're tying into hardscape. The client says, no, don't even know if this project's going to be built yet, just trying to get entitled. I don't want to invest that money. No problem, right? No problem. You go, you do the survey. The developer gets the project partially entitled or fully entitled, sells it to a different entity. They come in to do design. They see your topo survey. your UAV aerial and your contours. They do a design on that. They go to build. Turns out, the aerial wasn't accurate enough for a good design, especially in areas where there's hardscape. And the developer or the contractor that's building the project or the engineer that did the plans sues you. They say you were negligent, you produced a bad topographic survey. That happens. I've seen that happen in my career. It's never happened to me personally, but I've seen it happen. And the issue there is you were hired to do a survey for a different purpose. You did an aerial topo, which is totally appropriate for planning purposes, and somebody misused that for design, final design. Right? You didn't get paid to do a survey that would have supported final design, but you're still going to get sued. So that's what you're trying to protect yourself from in the licensing agreement. Right? You say, I'm willing to be liable for my negligence for this intended purpose. If you step outside of that purpose, the purpose for which I created the survey deliverable, I'm not going to be liable. So a licensing agreement or licensing language in your contract can help with that. Now, I will tell you, this is not the hill I die on most of the time in contract negotiations. So licensing and data ownership is not the battle I fight to the death usually with the client. If they want to own the data, we are happy to work with contract language that says that, as long as we get some reasonable guardrails around it. It doesn't come up very often. I'd say maybe 1 out of 10 clients says, "Hey, we don't like the way your contract's written. We want to own the data." We say, "No problem. We can do that. Here's some couple things that we'd like to talk about. Just some guardrails if you want to own the data." I'm way more worried in contract negotiation about payment terms, indemnification, insurance requirements. That kind of stuff is way more important to me from a liability perspective. But as a land surveyor, you should know what's in your contract. Do you own the data? Does the client own the data? If the client owns the data, do you have some guardrails in place to protect yourself? If you own the data, what rights are you giving to the client? How are you doing that? Are you doing it with a license? What I'm trying to do in this episode is increase your level of awareness about these issues. We almost all of us now deliver digital. We provide digital deliverables to the client. And this is a blind spot that we have. We need to think about it. Who owns the data? What are acceptable uses? How do we protect ourselves? Speaking of protecting yourself, in the next section, I'm going to talk a little bit about this will be part 3. What are some things you can do with the way you set up and manage your files to protect yourself from liability when you have a digital deliverable? And I don't know that we have this all figured out yet at Redefined Horizons, but I'm going to give you some suggestions. I'm going to take a quick bathroom break. When I come back, we'll get into part 3, kind of the technical side. What can you do on the file folder management side to protect yourself with digital deliverables? In part 3, we're going to talk about some technical things you can do on the folder file management side to help manage your liability and your risk when you're making digital survey deliverables. And we're basically trying to manage 2 problems with digital files. One is that they can be modified. So digital files can be modified after delivery. What happens if somebody, an architect or an engineer changes a drawing and it results in a construction issue, for example. And as I mentioned before, all digital files can be modified, even PDFs. And then the other problem we're trying to manage, and this happens, it's more of a problem on large, complicated projects, is files change all the time. Construction plans change. Survey alignments change. You go back, you do more survey work, you update data, you add features. So there's a versioning issue that you have to deal with also. So how can you address those 2 problems? So the first thing you can do is you can try and develop mechanisms to prove file integrity. So you can use what's called a checksum. That's a unique digital fingerprint of a file. There's some algorithms that generate those: MD5, SHA-1, SHA-256. If any of the data in the file changes, the checksum changes. So it's like a digital fingerprint of a file at a specific moment in time. You can generate a checksum when you deliver the file, document it in your records or your transmittal. Then if there's any issues about who made changes to a file, you'll have some ability to prove if the file that was used for the change, that was used in a manner that created the problem is the same version of the file that you shipped. And there's some different tools you can get that will help you generate those. I'm not doing this yet, but I need to after this podcast episode. I'm going to make a note that I need to do that, and I'll try and share some more. Maybe we'll do a PYBO team extra about that. But that is definitely something that I would like to implement. Okay, what else? You can use digital signatures. I haven't done that yet, but Adobe Acrobat supports digital signatures for PDFs. Apparently, that is a little bit like a checksum. I need to do some more research on that. Maybe I need to start digitally signing my PDFs. I'm not sure. I've never done this, but I think you could also potentially set up a system on a big project where you had a third party that hosted files, maybe hosted the authoritative version of files with their checksums. I mean, that could even be you. That could even be your survey company on it. Maybe you're hosting the authoritative version of files for the client. That could be a service you provide. Or maybe it's a third-party service. I don't know. I need to think about that. Again, something I need to do some more research on. I'm not doing that yet. Let's see, what else? I think you need probably to implement some system for versioning and change tracking. Come up with a version numbering system, track revisions with dates, figure out a way to notify clients and interested third parties of changes. We could do a better job of this here at RH. I don't have a formal system, but I need to get one in place. Part of the reason we haven't done that yet is because we're not working in-house with civil engineers. I think if you're working with an in-house design team, that becomes even more important because those design teams often have the ability to just go in and snag files, snag survey files without maybe fully understanding the level of completeness. So we don't deal with that as much here. But it still would be a good idea, I think, for us to implement a file versioning system. So I need to think some more about that. Again, something we might be able to do. PYBO team extra. So use checksums. Have some kind of versioning system in place. And then think about what's your delivery mechanism for large files if they're too large to email. You need to use a file sharing service. If you use a file sharing service, how do you track, who downloads what and when? We have a pretty simple system here. We have a communications folder. There's 3 subfolders. There's an in and out and a folder that we call internal. So anything that comes in on the project goes into a folder with the date, in theory. Anything that goes out to a client or a third party goes in a folder with the date. That's a pretty effective system for us, but I could see how on complicated projects that system might break down a little bit. So you got to do something that works for you. In the next section, I want to talk a little bit about file retention. So this is another key part of managing digital files. As a licensed professional, you have some obligation to maintain your files. Every state is different. I know I'm almost certain in California our statute of limitations is 10 years. I strongly recommend you retain files for at least 10 years. For at least your statute of limitations. So for me, that would be 10 years. So that means you have to have a system, to back up your data and have a way to organize it and be able to access it. 10 years is a long time. As a professional land surveyor, I'm going to produce a lot of data in 10 years, like probably terabytes, because the type of work we do, orthophotography and LiDAR and photogrammetry and some GIS work, I am going to produce a lot of data. It's not just drawing files here, but it's also drawing files and technical reports. So you got to have a way to retain that information, right? Check your state law, understand that. Have some agreement with your client about how long you will retain files. Clients have a bad habit of losing files or deleting files. We generally tell clients. I think we usually keep it pretty short. We generally tell clients we'll hang on to their files after a year. I mean, for a year, but then after that, they have some responsibility to keep their own backup. But that should be spelled out in your contract. Absolutely. We could do a whole different episode or podcast on file retention and what do you keep. I need to do. Maybe I'll do that. Maybe we'll do an episode on file management and file retention. But give it some thought. It's part of how you manage your liability with digital deliverables. All right, let's see. I'm just seeing how I'm doing on time here. Okay, the next part of the episode, I'm going to talk about some common problems we see with digital deliverables. And if you've been surveying for very long, this isn't going to sound strange to you, but I wanted to talk about it in case we have some younger surveyors listening to the episode. So one problem that we have with digital files is things get moved. Architects are notorious for this. They like to move things to 0, 0. So things get moved, sometimes intentionally, sometimes by accident. Sometimes it's a coordinate reference transformation that the software does automatically. So you got to think about how to mitigate that, prevent it, and mitigate it as a consultant, as a surveyor that's making digital deliverables. One way you do that is by having clear information on the project coordinate reference system and datums, map projection. I think the real solution is to have physical control points on the project site that someone can check into if they need to, another surveyor. I think that's really important. But give that some thought. Coordinate system mismatches happen all the time. I just had this happen to me on an infill development project we were working on. We did some of the initial boundary and entitlement work. The land developer hired a civil engineering firm. The civil engineering firm thought it'd be a great idea to come in and cut us out of the topographic surveying and utility mapping for the design, which was fine. But they never got our control. So they tried to fit stuff together off a couple, rusty iron pipes and a manhole lid. And there was a 3 or 4 tenth horizontal shift in the topo they did and basically our boundary. And then we had to deal with that, and it was a mess. 4/10 isn't a huge deal, but it's enough to measure. And so we had to, they created extra work for us and the client because they didn't just call and get our survey control. So coordinate system mismatches are a real thing and they matter. The other interesting thing that comes up with digital deliverables, we've been dealing with this here in California, is when a digital deliverable enables unlicensed practice and what your responsibility is as a land surveyor in that situation. So there's a lot of surveyors that are of the opinion in California that you shouldn't provide your survey control, because if you do, it allows the contractor, to do their own layout and construction staking. I have mixed emotions about that. As a general rule, we always provide control survey information with our surveys. There's a technical report. We try and get, if there's going to be a set of design plans, we try and get the design team to put a control sheet in the design plans. Now, there are some surveyors, I think they're a minority, but there are some surveyors in California that would like to have a world in which providing that kind of control information makes me partially responsible for unlicensed layout by the contractor. I don't know if I agree with that approach. It's not something I have fully thought through. I understand why surveyors might take that view. Unlicensed layout by contractors is a huge problem in California. I don't think obscuring accurate information about the project coordinate reference system and the control, I don't think that's the right solution. But it's something that we have to think about. It's an issue you got to consider, and you should spell it out in your contract, right? You should spell out what information is going to be provided as part of a digital deliverable. And does that include survey control coordinates and coordinate reference system information or not? So those are the two big issues, I think. Another issue that's come up with me on some projects is when the civil engineer starts mashing together data. They get some publicly available GIS data and they start mashing it together with your survey, and then things don't line up, and then they're calling and there's questions and there's problems with the design. I'm not sure. I need to look. We may have a clause in our contract that addresses integration with third-party data and who pays for the problems that come up when that happens. But if it's not in your contract, you should certainly think about it. I believe you should think about that. That's another thing that you need to address. All right, I want to talk a little bit about digital deliverables when you're working for a public agency client, because a different set of rules apply there. So with most public sector contracts, so federal, state, or local government, they're going to require that they own the data. They're going to want full data ownership. And I don't disagree with that necessarily. I think if the taxpayer is paying for the data, there probably should be transfer of ownership rights for that data. But that involves some increased liability for you, and you need to consider that. So as a general rule, governments in the United States at the federal, state, or local level are going to get unlimited rights to the data. So what does that mean? That means that they can use, modify, reproduce, release, or disclose the data in whole or in part in any manner they want for any purpose whatsoever, and let others do the same thing. So essentially, you put your data in the public domain. If you're curious where that is, where that regulation is, or which part of the government statute authorizes that, it is in the Federal Acquisition Regulation, specifically FAR Part 27, and the clause at FAR 52.227-14, Rights and Data General. So there you go. There's the reference if you want it. That's the federal. Most states have the same or similar language. How do you protect yourself in that situation? It's tricky. So first of all, you got to remember your work isn't going to be confidential in that situation. Your competitors are going to have access to it. You got to factor that into your pricing. You have to be careful about not transferring intellectual property or information that's truly proprietary. I would, in a situation where I was working for a local government agency, I'd be super careful about, what parts of my title block and in my, standard notes got transferred in drawing files. I'd be careful about that. Maybe you have a more generic version of your standard deliverables that go to government agencies because you're trying to protect that intellectual property. We don't do a ton of work for government agencies, so we don't deal with this a lot. We do a little bit. We do some work for one of our local counties, and we occasionally will do some city work. Most of that work I've done is the deliverables have been records of survey, typically, or corner records. Yeah, I don't know. It's something to think about. What do you put in a standard GIS deliverable or topographic mapping deliverable to a government agency, and what protection does that have? I don't know that I fully have an answer to that question. If you deliver sheets with your title block to a government agency, can a competitor use your title block? Yeah, I don't know. I don't know. It's something to think about, though. You should think about it. I'm sorry I don't have better answers here. Something I need to think about more and research more. So there's some limited ability. You're just going to be limited in what you can protect when you're working for the government. So what can you do? Understand how data rights are handled in your government contracts. Probably can't negotiate it, but at least understand what you're signing up for. If you're going to use proprietary data or you have proprietary methods, intellectual property. Intellectual property. Be very careful about what you include in a government deliverable. You need to make some effort to separate that stuff out before you ship your deliverables to the government agency. How can you limit your liability in those situations? It's hard. It's hard to So if you do a survey for the government, and the government takes your data, and then they distribute it. They put it up on a website, and a third party gets it, and there's a problem, and they sue you directly as a surveyor. How do you limit your liability? There's not a lot you can do. Remember, copyright's probably not going to protect you. So what are some things you can do? Meet your standard of care. You should be doing that anyways, but I would be extra careful on a government contract about documenting how you meet the professional standard of care. Make sure you have technical reports that go with your deliverables. Make sure you put your limitations of your scope. Make sure those are clear. Make sure they get communicated in the deliverables somehow. I always worry about a technical report getting separated from a drawing file or a GIS file. So to the extent that it's possible to do so, I would include your limitations in the digital file if you can. It's easier to do that with like a CAD drawing than it is with the GIS deliverable, but do what you can. To the extent possible, limit third-party reliance. There's going to be some limitations on what you can do with the government contract, but research that. It's going to change depending on whether you're dealing with a federal agency, state agency, or local agency. Understand, what your mechanisms are to limit reliance by third parties, and do your best to take advantage of those provisions. Now, we do have, if you're in California, the good news is we do have some extra protection. This was passed, Senate Bill 496 passed in 2017. I actually worked with ACEC California on this a little bit, and it does provide some protection for licensed professionals, including licensed land surveyors. It basically says that government contracts cannot pass full indemnification responsibilities and liability onto a consultant like a land surveyor. You can only be liable for your own liability, and you're only responsible for the portion of the damages that can be attributed to your own liability. So that is an important protection. It's not 100% protection, so just be aware of that. It is a little tricky. Digital deliverables are a little trickier when you're dealing with the government. So just make sure that you understand that. I think I talk about it. I can't remember if I talk about it. I do. I talk about it in one of our other contract episodes on contracts. This idea of privity of contract, which means people shouldn't be able to sue you if they don't have a contract with you. And the problem with privity of contract, which I think is a good legal concept, is it's been eroded over time in the United States. But privity of contract is exactly what you need in the situation where you're making survey deliverables. You're providing survey deliverables to the government, right? Your contract is with the government. Somebody downloads your LiDAR data from a government website, and then they use it inappropriately and sue you. You would like to go get summary judgment or get a dismissal of the lawsuit under the privity of contract doctrine. Now, you might still be able to do that, and I think you should make that argument with your lawyer. But just understand that privity of contract is being eroded, and so there is an extra degree of exposure with a government contract as it relates to digital files that you don't have with a private contract. So you should think about that and price that risk. You should absolutely price that risk. One thing my research mentioned, and I'm not sure how accurate this is, but I'm going to just spit it out here. I'm going to throw it out here so that surveyors can investigate it on their own. But that is the idea of using a reliance letter or a non-reliance letter. So it's a letter that you provide with your deliverables that says, hey, this data is being prepared only for my client. If you want to rely on it and be in a position where you have the right to sue me, you have to get my permission, and there's going to be terms with that. You're going to have to pay for that reliance. So I have some example contract language or deliverable language. This survey is for the exclusive use of City of Oakdale. Third parties may not rely on the survey for any purpose without express written permission from Redefined Horizons. Unauthorized reliance is at the third party's own risk. I would put that in. It can't hurt. Put that in your deliverable. It can't hurt, right? It can only help you. That doesn't mean it's going to give you full protection, or that a government agency probably isn't going to put that in your deliverable that they throw up on their website for download. So, all right, we covered a lot of ground. That was a lot. We have some other things we want to talk about. I want to do some more research about checksums and file versioning and third-party file hosting. And there's just so many issues here that I haven't fully thought through. And and I need to do a better job. My partner Brian and I probably need to think some more about this, and we need to do a better job of this at Redefine Horizons. I hope that helps you guys. I hope you think about it, and think about, when you get ready to sign your next contract, carefully look at the way ownership of digital data is handled, and what you find might surprise you. It'll probably educate you a little bit. It's something that we can all be more aware of, I think, as professional as professional consultants and land surveyors. So, thanks for listening, guys. I will catch you on the next episode. As we close out the episode, we just want to give you guys a few reminders. First, we want to let you know where you can find the podcast episodes. The podcast home on the web is at my personal website, landonblake.com. If you head there and look under the Learn menu, you'll find a link for the podcast. That homepage for the podcast has all of the episodes. You can download those in MP3 format if you'd like, or read the show notes. You can also find the podcast on Spotify, YouTube, and Amazon Music. So if those are one of those is your preferred distribution channel, you can find the podcast there. We also want to let you guys know, if you'd like to sponsor the podcast, you can reach out to me, sunburn.surveyor@gmail.com. You can also send me questions, comments, thank yous, topic suggestions for the podcast. I regularly get that kind of feedback from listeners, and I dig it. I appreciate hearing from you guys, so I encourage you to do that. We also have a Patreon page. If you cruise over to Patreon, you can search for On Point Workshops, and you will find the podcast there. You can, for a small monthly donation, I believe right now it's $10 a month, you can support the podcast and get access to what we call PYB OTM Extras. So those are extra videos, short audio files, and even full episodes of the podcast. And that support on Patreon allows me to keep Carly around. Carly is the fantastic young lady that helps me edit the podcast and maintain the podcast website. We'd like to keep her around, so we appreciate your support on Patreon if you're able to do that. And thank you for being a listener.